A statutory will is a special will made by the Court of Protection for people who don't have capacity or the understanding to make one for themselves. As like with everyone else, you need to be at least 18 years of age before you can make one. You might need a statutory will in several circumstances. Firstly, if you don't already have a will, your estate would pass under the intestacy rules, and you might need one to put your affairs in order. Secondly, if someone already has an existing will, this might need to be updated to reflect the current circumstances. And thirdly, if there are any troublesome or difficult family dynamics, a statutory will might prevent a potential dispute post-death. Before you can get a statutory will, the first thing you need to do is obtain medical evidence to show that the person cannot make a will in the usual way. Once that's been obtained, you would then make an application to the Court of Protection, including a proposed statutory will and an explanation as to why it is in that person's best interests for that to be approved. The application can be made by an attorney, deputy or beneficiary under the will or under intestacy rules, and it usually takes about 6 months, but it can take longer if disputed. However, that being said, the court can consider applications on an urgent basis if there is a very short life expectancy, but you would need to clearly demonstrate this in the application. In the statutory will, you can ask for all the regular provisions, so for example, the appointment of executors, funeral wishes, leaving gifts to friends and family and possibly to charities, and it would also discuss how you would wish the estate to be left amongst friends and family. The court, however, would need to be satisfied that the will would be in that person's best interests. This can be sometimes tricky to show, but one would expect someone to consult with friends and family and also consider the person's past wishes and feelings. And if the testator can voice an opinion about how they would want their estate to be left, this is something that the court would want to hear about. A statutory will has exactly the same effect as a will drafted by someone else. The only difference is the way in which it is made.